So here's a fascinating story. 20 years ago, if you told a room full of human rights lawyers that people would be suing governments over climate change, they would have looked at you like you were crazy. In fact, when a climate lawyer tried to get major NGOs involved in the first ever legal action of this sort in 2003, they told him, those aren't human rights. You're diluting what human rights really means. But here's what's remarkable. Today, courts around the world are ruling that governments have violated human rights by failing to act on climate change. So the question is, how do we get here? What changed? The story begins with indigenous leaders and climate advocates like Sheila Watt-Cloutier, an Inuit elder from the Arctic. In 2005, she and her lawyers filed the world's first rights-based climate case before the Inter-American Commission on Human Rights. Their argument was this: greenhouse gas emissions were melting the Arctic, destroying the Inuit way of life, and violating their fundamental rights. What her people were claiming was the right to be cold. I love that sentence. It was this powerful reframing, moving climate change from abstract environmental science to immediate human suffering. So what happened with the case? The commission dismissed it, but something had really shifted. The case caught the world's attention and showed that human rights could tell powerful stories about global warming. As Watt-Cloutier later wrote, we had cast our line to see what fish we would catch, and instead we caught a whale. Together with pioneering cases filed in other jurisdictions, the Inuit petition opened the way for a legal transformation that disproves the view that law doesn't change and that little can be done against climate change. At a time when whales, both literal and figurative, are endangered, these videos show they still exist. Now, for the next decade, the idea spread slowly. I first witnessed this evolution firsthand when I participated in a series of workshops in São Paulo between 2016 and 2019. Brazilian organizations were exploring whether to file their own climate suit, inspired by early successes like the Urgenda case in the Netherlands. I remember the room being filled with hope and skepticism in equal measure. The big question everyone was wrestling with was, could courts really address something as massive and complex as climate change? Meanwhile, legal precedents were emerging worldwide. In Pakistan, farmer Ashtagar Legari successfully sued his government for failing to implement climate laws. In Colombia, young people won a landmark case protecting the Amazon. And in the Netherlands, again, the Urgenda Foundation achieved the improbable, forcing their government to cut emissions faster. These and other cases established a crucial principle. While climate change affects everyone, courts could still recognize individual harms and hold governments accountable. But here's what made this transformation possible. It was really an unlikely convergence between two completely separate worlds: human rights law and climate governance. For decades, these fields had run on separate tracks. The UN Human Rights Council avoided climate issues until 2008. Even the 2015 Paris Agreement only briefly mentioned human rights in its preamble. But by the mid-2010s, things were changing. Science was revealing the devastating impacts of global warming on human life. The Paris Agreement created goals, but really lacked enforcement mechanisms. Human rights advocates came to recognize climate change as one of the greatest human rights challenges of our time. So what did rights-based climate litigation really create? It was something really new. A hybrid system that takes climate science and international agreements as benchmarks, then uses human rights law to make them legally binding at the domestic level. Let me walk you through the doctrines that have emerged in this body of law. The Common Ground Doctrine means courts now integrate climate science, like the IPCC reports, with human rights law. On justiciability, climate change went from being seen as too political to a core judicial responsibility. For standing, courts developed new ways to recognize climate harms as individual injuries. The legal stock was in place. The mobilizing frames had been tested. Now litigation could flourish. By 2024, over 467 rights-based climate cases had been filed in nearly 50 jurisdictions. What began as Sheila Watt-Cloutier's right to be cold had become a global legal process. But this was just the beginning. The real question wasn't whether courts should address climate change, but how they would reshape the law to meet this unprecedented challenge.